So hey everybody, and welcome to TrackLight's webinar. We're here today with Nicole Druckrey on trade secrets. My name is Emily Ely, and I am with TrackLight, online media specialist here. And I just wanted to thank everyone who has joined us, and thanks to our presenter, Nicole. Just a little bit about Nicole. She is a partner at the law firm of Quarles and Brady, and is the chair of its Trade Secrets and Unfair Competition Group. She regularly handles disputes over non-agreements, trade secrets, allegations of fraud, breaches of the duty of loyalty, and contract breaches. She successfully pursued and defended against a number of injunction requests, and Nicole has represented clients in a variety of industries, including manufacturing, technology, retail, and construction industries. So as you may know, part of TrackLight's mission is to help entrepreneurs and startups identify and protect their intellectual property. So we're very excited today to be learning about trade secrets and the importance of trade secrets as an integral part of your IP arsenal. So before we have just a couple of housekeeping items. If you haven't yet, please be sure to mute your microphone. We are going to hold all the questions until the end to just try to keep the flow of the webinar going. Speaking of questions, if you have any throughout the webinar, you can those to Emily and myself in the Join Me chat bubble, and that's on the little app you'll see right next to the phone component. And so you can go ahead and send those to myself, or you can tweet those to #TrackLightWebinar on Twitter. If we run out of time to your questions, we will at the end, and we'll make sure to recap those in our blog tomorrow, and that'll go live at 9 a.m. on the website. So if you aren't subscribed for our blog, be sure to check the TrackLight website and register for our blog. And then lastly, these slides will be on SlideShare shortly after the webinar, and as usual, you'll be able to access all of this information on the resources page on our website under Webinars by TrackLight. So without further ado, Nicole, I'm going to the presentation over to you.
Great, thank you.
All right, there you go.
Well, welcome everybody, and thank you for allowing me to present to you today. As Emily mentioned, my name is Nicole Druckrey, and I am a partner at the law firm of Quarles and Brady in Milwaukee, Wisconsin. And I frequently handle disputes involving trade secrets. I've handled such disputes in a number of states across the country. And as Emily also mentioned, I'm chair of Quarles' trade secret subgroup, which obviously focuses on these matters. So today's presentation is right up my alley, and I'm happy to be here today to talk to you about trade secrets. And I have three goals, really, for the presentation today. The first is to educate you as to what a trade secret is or what it can be. The second is to give you advice on how to protect your trade secrets. And the third is to provide you with my tips and advice on what to do in the situation where you think your trade secrets may have been stolen. And before we dive into what a trade secret is, I want to take a small step back just to give you some context. As you're probably aware, there are a number of ways to protect your intellectual property. You can protect them with a patent, you can protect them with trademarks, you can protect them with copyrights, and you can protect them by guarding the item as a trade secret. And the trade secret option is really probably the least known option of the possibilities. And a couple famous examples of trade secrets would be the Coca-Cola formula. That has always been protected as a trade secret. The second would be the KFC Original Spice Mix has always been protected as a trade secret. And there are some benefits to opting for trade secret protection as opposed to, say, doing a patent. The first is the fact that there's no time restriction. So if you apply for and secure a patent, typically that has a limited duration. I believe it is presently 20 years. So if you apply for a patent, it's good for 20 years. After 20 years, your patent will disclose what is patented, so everyone will have your intellectual property and can use it after the patent expires. With trade secret protection, there is no such temporal scope or temporal limit. The trade secret protection can last for so long as the item maintains its secrecy. So hence, the secret Coca-Cola formula that's been protected for decades because it's remained a secret. One other benefit of opting for trade secret protection is that you are afforded a broader scope. Well, trade secrets can protect a broader scope of items. So, for example, one item we'll talk about here in a little bit is customer lists as a trade secret. That is something that may be a trade secret. It is not something you could protect, say, with a patent. So trade secret status offers or is able to protect a broader array of items. Also, opting for trade secret protection is in some respects easier. You don't have to go through the rigmarole of applying for a patent and maintaining that patent and defending that patent. With a trade secret status, you decide, okay, I'm going to protect this as a trade secret. And then you need to embark upon some, as we'll talk about, some security measures to maintain the secrecy of it. And that certainly will require some time and effort on your part. But in some respects, you don't have the upfront cost and rigmarole of having to apply for a patent or anything like that. So moving on, what is a trade secret? Trade secret is defined by state law. There is no federal statute governing a civil suit or a civil party's rights as to trade secrets. There is something called the Economic Espionage Act, and that provides some criminal remedies in the event a trade secret has been stolen, and we'll touch upon the Economic Espionage Act a bit down the road here today. But for our purposes, we're talking about the trade secret law that would apply or provide you with protection in the civil context. And virtually every state in the Union has adopted something called the Uniform Trade Secret Act. Now, it's been adopted by about 47 states, including the District of Columbia and the U.S. Virgin Islands. And those states may have modified the Uniform Act a bit, tweaked it to address special concerns that the state has. But for the most part, or for our discussion today, the 47 states that have adopted it have adopted the same statute. The three holdouts are Massachusetts, New York, and North Carolina. Those three states have not adopted the Uniform Trade Secret Act. However, they do have state laws protecting trade secrets. And those laws will differ from the Uniform Trade Secrets Act. However, for the purposes of our discussion today, there really is no significant difference between the Uniform Trade Secret Act's definition for trade secrets and those three states' definitions of what constitutes a trade secret. So, jumping ahead to what is a trade secret. The Uniform Trade Secret Act defines a trade secret. Hold on one second, I have to move this little dialog box so I can read it. The Uniform Trade Secret Act defines a trade secret as, trade secret means information, including a formula, pattern, compilation, program, device, method, technique, or process that, number one, derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and two, is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So what does that mean? Essentially, a trade secret, for something to constitute a trade secret, it needs to have two components. It needs to be something that would be of value to a competitor, and number two, it needs to be subject to reasonable efforts to guard its secrecy. So those, really the definition boils down to those 2 points. Is it something that would be of value to your competitor, and do you take efforts to maintain its secrecy? Now, if you're in front of a court and the court is considering whether or not the item at issue is a trade secret, they'll typically look to that definition if they're in one of the 47 states, but they also often consider the 6 factors that are on the slide in front of you. So number 1, the court may consider the extent to which the information is known outside of the business. Number 2, the extent of measures taken by the business to guard the secrecy of the information. Number 3, the ease or difficulty with which the information could be properly acquired or duplicated by others. And let's step back and take an example there. Going to customer lists, which can be a trade secret. They're not always a trade secret, but they can be. And consider the following scenario. Your customer base is any pest supply company in the state of Iowa. And so you task an employee with going onto the internet. Let's say they go onto Dex Online and search for any pest control company in the state of Iowa, and they print off a list. And that's your list of prospects. That is likely not protectable as a trade secret. It required very little effort to do. It maybe took that employee 15 to 30 minutes to go up or go onto the internet and print that off, and anyone could very easily duplicate that. Contrast that with, say, for example, you employ a number of financial investment advisors. As part of their duties, they are required to go door to door on residences in their territory. When they knock on the door, if they get a positive response, they ask the individual about, say, annual income, value of their property, how they are currently invested, what their investment goals are, whether or not they consider themselves a conservative investor or whether or not they are more accepting of risk, whether they have any children, whether or not their children will be attending college anytime soon. And the financial advisor writes all that information down. They go back to their office. They open up an Excel spreadsheet. They place all of that information in the spreadsheet. They may go on the internet and do some supplemental research about, say, demographics for that neighborhood, annual income, average annual or average home value, and they supplement the spreadsheet with that information. That can definitely be a trade secret. It required significant time spent by your employee to research and gather that information. It was supplemented with internet research. And so in that situation, that could certainly, I think it's likely to be a trade secret. It was, difficult to acquire. It was time-consuming to put together. So returning to the factors the court may consider. Item number 4, the extent to which the information is known by employees and others involved in your business. The value of the information to the business and its competitors, and the amount of effort or money expended by the business in developing the information. So some common examples of trade secrets. A customer list, as we've already touched upon, can be a trade secret. As we discussed, simply printing off a list of customers from Dex Online probably is not a trade secret, but if you've supplemented that list with additional information that you've gone out to the field to collect, that very likely is a trade secret. Pricing models could be a trade secret. And to kind of compare and contrast what is and isn't in that regard, say, for example, you give your employees a price list, they keep it by their phone, a prospect calls and inquires about pricing for a certain item, the employee refers to that price sheet and gives out that pricing information. That is probably not a trade secret. That's information that you give out to pretty much anyone who calls. Contrast that with, let's say you've developed an Excel sheet that considers a number of factors in computing a price. So it will consider, years that the customer has been in business, whether or not the business or whether or not the customer will be paying in cash versus credit, whether the past order history of the customer, the volume that the customer is desiring to purchase, whether or not you anticipate there'll be subsequent purchases down the road. And let's say your formula that you've created considers all of that information and kicks out a price. In that situation, you very likely have a trade secret. Manufacturing processes can be a trade secret, as can product design information. And here's where you can have an interesting interplay between patent law and trade secret law. I've had a number of cases where the client has protected the product, its design, with a patent. But there are also unique components to the manufacturing process that the client guards as a trade secret. So that end product is protected not only by patent law, but by trade secret law as well. So it's possible to have a situation where an end product is protected by both trade secret and patent law. Strategic plans can certainly be a trade secret. Algorithms and formulas could be a trade secret. I recently had a case involving roller bearings, and the client had sort of developed over the years this complicated formula that would tell the client how to design a roller bearing based upon a number of factors that would be inputted from the customer. That was certainly protectable as a trade secret. One tip, this may seem silly, but it is helpful. I would advise you to name your trade secret or name the item you desire to protect as a trade secret to increase the likelihood that a court will actually consider it a trade secret. And that it costs you absolutely nothing to do. It may sound silly, but you have a certain level of credibility if I go into court and say, Your Honor, you know, John Smith stole my client's customer list upon his departure. The client or the judge hears the word customer list, and they're already suspicious because they know there are some occasions where the customer list is not going to be a trade secret, in some instances where it will be. And so you've already kind of got an issue where the judge may be looking at you with a bit of skepticism. Contrast that with a situation where, going back to the financial advisor we were talking about earlier, let's say that database that the financial advisor puts all of that information into you call the Cricket database. So now I'm in court and I'm saying to the court, Your Honor, John Smith, before he departed, printed off a copy of my client's Cricket report. The Cricket report contains X, Y, and Z, and automatically it shows the court that you have given some consideration as to what your trade secrets are. You've identified it, you've named it, and that is all helpful to the court. And while it may seem silly, it costs you nothing to do, and I promise it will give you a different level of credibility going into the court. So consider naming the item you consider your trade secret. Before we move on, let's move on. So what is not a trade secret? Two things, general knowledge common to the industry. So let's say, for example, you process cranberries, and during the winter you store your cranberries, and you, like every other cranberry processor in the market, stores it exactly the same way during the winter. Now, the public doesn't generally have that information, but everyone in the industry does it the same way. That's not a trade secret. It's not specific to your organization. While the public may not be aware of it, you know, they're not aware of it because they don't care, and your competitors do it the exact same way. So that's not knowledge that's common in the industry, even though the public may not know it. That is not a trade secret. As an additional example, publicly available information is not a trade secret, except if you have to sort of compile a number of some public information from a number of sources, and you compile that together, and that's time-consuming, that could be a trade secret. So as a couple examples to flush that idea out, let's say you are in the business of bidding on government contracts. You instruct your employee to go online to your state's website and print off a current list of the bidding opportunities. That list is not your trade secret. Anyone can go on that website and get that information in a matter of seconds. Contrast that with, let's say each state has information, the government of each state has information that is helpful to your marketing or some product that you produce. And so you task a single employee with once or twice a year submitting a Freedom of Information Act or state equivalent request to each of those state governments to get that information. So in that situation, the information is publicly available, but you have engaged in extensive efforts and costs to gather that information. You've tasked an employee with doing it once or twice a year. They're going to have to submit requests to all 50 states. They're going to have to follow up on those requests. In the event the state resists giving the information, the employee is going to have to follow up, and that's going to be time consuming. So in that situation, the compilation of the public information could be a trade secret. My advice to you in determining whether or not you have something that is a trade secret is, if it is valuable to your valuable to you and valuable because your competitors don't know it, treat it like it's a trade secret. Don't worry so much about whether or not in the end a court is going to conclude that it is in fact a trade secret. Just treat it as it is. You don't need to go talk to a lawyer at this point about whether or not what you have is a trade secret, although you certainly could do so, but you don't need to at this point. If you have something that's valuable to your company and you want to treat it as a trade secret, do so, and then worry down the road in the event that it's misappropriated or stolen and you need to litigate the matter. At that point, you'll worry about whether or not it's actually a trade secret. So reasonable security measures. So as we talked about, a trade secret has two components. Number one, it has to be something that has value, would have value to a competitor. And number two, you have to take reasonable security measures to protect its secrecy. And this latter item is frequently the subject of litigation. You will often, I will often spend in cases a significant amount of time arguing about whether my client or the defendant, or I'm sorry, my client or the opposing party has taken significant efforts or sufficient efforts to protect the secrecy of the information. And so here are some very, some easy, simple things you can do to preserve the confidentiality or to show that you've taken reasonable security measures. First and foremost, stamp the item confidential. You would be shocked at the number of cases I have where the client comes to me and says, Joe Smith left our employment. We think he took X, Y, and Z with him. We consider those are trade secrets. And I'll say to the client, okay, great, shoot it to me in an email so I can take a look at it, and they'll send me something that doesn't have confidential anywhere on it. Now that in and of itself may not be damning to your case, but it's certainly significant, and it's going to be an obstacle for you in the litigation. So first and foremost, if you have an item in paper or stored electronically that you consider a trade secret, mark it confidential. Insert a watermark or stamp it, whatever you need to do to designate it as confidential and to show that it's confidential simply by looking at the item. Number two, another easy item, require non-disclosure agreements both of your employees and of any vendor that's going to have access to that information. And so you may be thinking, well, why would I ever give an outside person access to my trade secrets? Say, for example, you are a company that treats boiling and cooling water systems. You have developed special formulas to treat the various issues associated with that. You consider those formulas to be your trade secrets. Others in the industry don't have them. But you yourself don't actually blend those formulas. You use a third-party vendor to blend the formulas for you. In that situation, you're going to want the vendor to execute a non-disclosure agreement wherein they acknowledge that your formulas are confidential trade secrets to you and that they are not permitted to disclose them. Same with employees. If you have employees who are going to have access to your confidential information and trade secrets, make sure that they sign a non-disclosure agreement. In that regard, you should be aware, as many of you may know, state laws can vary widely when it comes to covenants not to compete. In terms of, states may impose special requirements in terms of duration, geographic scope. States may have special notice requirements. They may require that the definition of items included in the covenant not to compete are flushed out, and consideration, special consideration may be required. And you're probably thinking, why does this matter for a non-disclosure agreement? Well, there are a number of states, Wisconsin, for example, that considers a non-disclosure agreement to be a covenant not to compete. And so in a state like Wisconsin, we need to make sure that our non-disclosure agreement complies with state law governing covenants not to compete. And so this may be an item where you don't want to just Google on the internet, confidentiality agreement, print it off, and put it into use. It's worth having a quick call with your lawyer to make sure that what you're using complies with the state law of the states at issue. Another item that's fairly easy to implement, and that is limiting physical access to the facilities that house their secrets. So let's say, for example, you consider your trade secrets to be engineering. You have these engineering formulas. You consider them to be trade secrets. The people who use those formulas are your engineers. In that situation, I would consider, if you're a large enough business, having a separate area where the engineers work. And so you will likely have, in that situation, a card key access to get into your building generally, but then a separate card key required to get into the engineer's room because that's where your trade secrets may be visible on computer screens or maybe printed out. Some other simple steps you can do require ID badges. You could use guards, if you have the resources to do so, security cameras, alarm systems. You can also employ sign-up sheets or sign-in sheets. So, for example, that engineering room, if you don't have the resources to employ some sort of card key system, you could have a sign-up sheet outside the door so that any employee entering or leaving that area has to sign in and out, so you have a record of that. You can also limit physically where the trade secret can reside in your facility, and that would be, the engineering example where we talked about, you have a policy where only the engineers can view the items and they can only do so in a certain room. Visitor policies, this is something that's fairly easy to implement. You can draft this yourself. You could have a policy that addresses the areas the visitor can address, or the areas the visitor can see, the areas the visitor cannot see. You could have a policy that requires them to be chaperoned at all time by an employee. You could have a policy that requires someone to do a sweep of the office before a chaperone or before the visitor comes in. So let's say you have someone coming in to do some maintenance on the AC unit. The AC unit is in the same room as those very valuable engineers and their trade secrets. You may have a policy then that requires someone to do a sweep of the engineer's room before that vendor comes in to make sure no one has the trade secret up on their screen, no one has it printed off. You can also require visitors to sign a non-disclosure agreement. Another relatively easy item is password protecting your computers and files. So, if you have company-issued laptops, required a password to even get on the computer, and then also limit access further to any files that contain your trade secrets. You can do that by requiring a password for those documents or having your IT administrator set it up so only certain people would have access to the areas where those files are located on the computer or your servers. Implement employee policies. So you could have an employee policy, for example, where they can't plug external devices into their work computer. That prevents a situation where someone could copy it onto that external device and then take it with them home or wherever, or potentially lose it or have it stolen, in which case it could end up in the hands of a competitor. You could limit forwarding of the information by policy to web-based email addresses. Set up a policy that says you are prohibited from forwarding any company document to your Hotmail account or similar web-based account. You could require that work be done on work-issued computers. You could also easily implement a policy that says, any item marked confidential should not be shared with anyone, even inside the organization, unless they have a need to know that information. So some tips for ensuring that your trade secrets do not walk out the door. Number one, demonstrate by example. If you are giving a presentation, let's say you're talking to your employees, you've called a town hall meeting, and one of the topics is going to be your strategic plan. And you're really going to get into the nitty-gritty details of your strategic plan. And while you're fine with all of your employees having a general overview of the strategic plan, the details are really only information that the managers need. So what I would recommend you do in that situation is hold your town hall meeting. When you get to the strategic plan, excuse the employees who aren't management, and then continue the meeting with just the management. That shows the employees how serious you consider the confidential nature of that plan and how seriously you take it. Also, if you've implemented policies that say you need to sign in before entering the engineer's room, you should do that. You should show that other employees that you take that policy seriously and you're going to do it. If you prohibit employees from using external devices in their work laptop, then you should not do that either. So keep demonstrating by example how serious you take your trade secrets. Another tip, train your employees. I will often have cases where the employee will copy a bunch of information before they leave, and they truly didn't mean to do it in order to hurt the company. They took it because they wanted to seem knowledgeable to their new employer who may be a competitor. And that's not good for your business. You still don't want that to happen. But oftentimes I think that happens because the employee just didn't appreciate that the employer considered that information to be highly confidential. And so train your employees. When they start working for you, train them on what you consider your trade secrets to be. Just tell them, we consider this a trade secret, we consider that a trade secret. Disclaim, this isn't an exhaustive list, but this is generally what we consider a trade secret here. And then train them on how to treat that. Point out your policies that say they can't, email those trade secrets to their home computer. They can't plug in an external device and copy it onto them. They can't share those trade secrets with persons even within the organization unless the person has a need to know the information. So be specific with them and do it right up front when they start. Also, I would recommend doing it on an annual or semi-annual basis going forward. Just a reminder to your employees. Maybe you call them in for a presentation and just say, just a reminder, here's what we consider our trade secrets. Here's how you should or should not treat them because we consider them trade secrets. Require them to acknowledge that they received the training in writing. Another method I've seen used, I recently had a case where the employer required employees, like once or twice a year, the employees had access to this database that contained the trade secrets, would be stopped from entering it by a little pop-up that said, as a reminder, everything in this database is considered confidential by the company. It contains the company's trade secrets. Click here to acknowledge that you appreciate this. And then to continue, they'd have to click on that acknowledgement. The employer kept a record of those acknowledgments, which can be very helpful come litigation. Another tip would be to conduct exit interviews with employees. And so, I've been practicing in this area for 11 years. And, the cases that get press are typically the cases where an outsider kind of sneaks in and takes the company's trade secrets and then they flee to a foreign country. You've probably seen a couple high-profile examples in the papers at various points. Those are the cases that get newspaper attention. But they, in my opinion, are not the common situation where trade secrets are stolen. The most common situation where trade secrets are stolen come from employees, and it happens when they leave your employment. So if an employee announces their resignation or you are terminating them, that is a critical time for protecting your trade secrets. And don't let that opportunity go without making sure you've protected yourself. So if an employee resigns or you are terminating them, sit down with the employee and have an exit interview. You may already be doing that already, and here's some ideas to incorporate into that interview. First and foremost, remind them of their obligations to preserve the confidentiality of your information. If there's a non-disclosure agreement or confidentiality policy, provide them with a copy and ask them if they have any questions. Invite that now. Also, invite them to ask you if they want to take something from their office or the computer. I've had a number of cases where the employee's defense is that, oh, yes, I did copy those, couple confidential files, but it was really, I was trying to copy all of my personal photos that were stored on my computer. These confidential files happened to be in the same folder as my photos, and I didn't want to sit there and parse through and pick out my photos from the highly confidential items, so I just copied the whole folder. I never intended to use the confidential information. I just wanted my pictures. And usually that answer is just a complete lie, but try and head off that excuse in the first place. Invite them to ask you if they want to take something. So you can say to them, we certainly appreciate that you may have some personal items stored on your computer, a tax return, pictures. If that is the case, then we will have an IT person sit down with you so you can parse out and show us what you're taking so we're confident it's not confidential to the company, and provide them with the opportunity to do that. Same with hard property, tangible items. If there is a binder in their office that they want to take, invite them to ask you permission. And by providing them with that opportunity, you put yourself in a strong position going into court if the employee failed to take you up on that. You also want to make sure you're collecting any property that was given to the employee while they were under your employee. So any laptop, any cell phone, make sure that you note the date and time, also that those items were collected. I have had cases before where that date and time becomes absolutely critical because, we'll have, we'll get the computer here in my office, we'll send it to a computer forensics vendor, and we'll say we suspect this employee did something fishy on their last day, and the computer forensic vendor will come back and say, well, it looks like some files were copied at such and such time. It also looks like a wiping program was used to delete files at such and such time. And then before we go into court, we want to make sure there aren't innocent explanations for those. So the first question we ask is, was it the IT person who maybe did that? Maybe they saw the computer, turned it on, looked at some files and said, I don't know if these files are on the server. I'm going to make sure they're copied onto the server. So he copies them, and then he wipes the computer clean before it's reissued to a new employee. You do not want to run into court without making sure it wasn't the IT administrator that has done that. I've actually had a case before where the client came to me and said, employee did X, Y, and Z on their computer on the last day. Please draft a letter to the employee. Often we'll draft a letter first before we file a lawsuit, demanding the return of these items. And so I drafted the letter, sent it to the client, and I said, now you're positive that the activity occurred prior to the time the employee turned in the device. And the employer said, I need to look into that. And sure enough, the activity that they were complaining about had actually occurred after the employee had turned in the computer. So in that situation, we obviously didn't send the letter, and it's a good thing we didn't. Had we sent the letter, and let's say it affected the employee's new employment, they might have had a claim against us for tortious interference. So it's important that when you collect the computer and cell phone and that, any other sort of electronic storage device, please note the time and date upon which you do so. It can become important down the road. I would also ask the employee at the exit interview to sign a statement acknowledging that they have returned all company property and they have not retained anything. That can be a fantastic piece of evidence to put in front of the court. If the employee did retain something but they signed that statement, well, now the court knows they're a liar, and that puts you in a great position in court. Also, once an employee resigns, immediately deactivate their employee's access card to the facilities and any computer access. I have had a case before where the employee didn't resign on a Friday, said they'd come in and turn in their items on Monday. The employer did not shut down the computer access over the weekend, and sure enough, the employee spent the weekend copying some very confidential information. So as soon as the employee announces their resignation, deactivate any access they have to your databases and servers. Also, if the employee is going to a competitor, make the resignation effective immediately. If you feel funny doing that, if you have a good relationship with the employee, you can say, it is our company policy that we do this. If you're going to a competitor, we will pay you for the 2 weeks, but we would, we're not in need of your services during the next 2 weeks. You're free to go. And the reason is you don't want to give them more time to do something bad. And I recently had a case where this actually happened. The employee resigned. The employer insisted that the employee stay on another 2 weeks, and the employee, who was disgruntled, spent that 2 weeks downloading confidential information, which he or she then took to a competitor. So if they're going to a competitor, feel free to make it effective immediately. I think most employers, well, a lot of employers these days do that, so it's not exactly abnormal. So the last topic is what to do if you suspect that your trade secrets have been stolen. And my first advice is to do something. And that may sound silly and not helpful, but imagine a scenario where, going back to the reasonable security measures, you have to take reasonable steps to protect your trade secrets. And let's say you have a situation where John Smith leaves. You think he copied a bunch of your trade secrets, and so you call your lawyer and you tell the lawyer, yeah, John Smith just left. We think he copied all our trade secrets. We want to go and seek an injunction. Let's do that. And so one of the first questions they'll say is, okay, tell me about, how you've protected this item. Did you have confidentiality agreements? Blah, blah, blah. Has anyone else ever stolen this item? And the employer says, well, yeah, Jane Smith left a year ago. She took a copy of it with her, we're pretty sure. But at the time, Jane Smith was a horrible salesperson. We were confident that even with, our infamous cricket report, that she wasn't going to be able to damage us, so we didn't want to spend the money and do anything. Well, that could be a problem. Now when John Smith has taken it and it's a big concern for you, the court may say, oh, yeah, but, you let Jane Smith go a year ago and she took the information. That to me tells me you don't really consider it a secret. So if you think someone has taken your trade secrets, regardless of what you think they can do with it, do something, contact your lawyer. In the situation involving Jane Smith, had the employer contacted me when it happened, I would have advised them to at least send a record, have some sort of documentation that would say, dear Jane Smith, best of luck in your future endeavors. I write simply to confirm that you haven't taken any of our property or possessions. If you have, please return them immediately. So at least then we can show the court, yeah, we did something. We sent her a letter, confirming that she hadn't taken anything and she didn't respond with anything, so we had no reason to suspect she had. So you've at least done something that is documented. Also, you want to quarantine any computer or electronic storage device at issue. So let's say, we're back to the employment situation. The employee has left, and you just, you can't put your finger on it, but something didn't seem right about the way they left, and you sort of suspect they may have taken something. Do not reissue that employee's computer to another employee. If you have to, for resource reasons, you don't have another laptop to issue, consider having the laptop imaged before you reissue it. Conducting a forensic image of the device doesn't cost too much. It's typically between $300 to $500, and then you have that evidence preserved should it become relevant down the road. Let's say you do, you have your suspicions, but you go ahead and reissue the computer to a new employee. The problem with that is that the other side then has an argument that you've destroyed or damaged evidence. And so the employee would go into court saying, how do they know it was me, Your Honor? They reissued it to another employee. That employee used it for 6 months. They could have changed the date stamps. This could have been their activity. How do you know this activity was me? And typically we can overcome those issues, but it's typically costly to do so. And it makes it more challenging to prove your case in front of the court. And so it is much easier to just quarantine the computer when it comes in. Don't let anyone touch it until you decide what you're going to do about the case, potential case, or have it in. Also, lastly, you can consider involving the authorities. And there's pros and cons in doing this, and there's also, the possibility that the authorities might not be interested. But this is particularly appealing when the party that you suspect of having stolen your trade secrets is not an employee. I think the authorities are more likely to pursue a case when it's a third party, especially if the third party happens to be from a foreign country. Most typically have appeal to the federal authorities. And as I mentioned earlier, there's something called the Economic Espionage Act. It's a federal statute that prohibits or criminalizes the misappropriation of a company's trade secrets. And as I've already indicated, the feds are more likely to pursue such a case if it's an outside, a third party that's stolen your trade secrets, not an employee, and in particular if it's a person from another country. If you do have a case where you think it's worth involving the authorities, and going back to the employee situation, I don't want to say it's never a good idea to involve the authorities when it's an employee. I recently had a case where the feds did become interested in a case involving employee theft. And so in that case, it became very helpful to us to have the FBI investigating the defendants. It quickly secured a quick settlement for our clients because the defendants were terrified about having the FBI knock on their door. But there can be some cons associated with involving the feds. If you think you have a case that's appealing to them, their involvement can slow things down. The criminal process does not necessarily move as quickly as the civil process. The feds may lose interest in the case, and then it sort of sits there languishing. It's possible that the defendant could move to stay any civil proceedings pending a criminal investigation or a criminal suit. So you want to consider that as well. And also it can prohibit settlement discussions. Sometimes a defendant will say, well, I'm not going to settle my case with you when the feds are still investigating me. I only want to engage, I'm only going to resolve this matter if I can resolve everything. But if there's still possibility of criminal prosecution, I'm not going to settle this. So it can hinder settlement as well. And so that's my presentation. And thank you very much for your time today. And I will hand it back to Emily, if you're there, Emily.
Yep. Thank you so much, Nicole. That was fantastic. I really loved all the compare contrast examples. It helped kind of, for all the entrepreneurs and startups out there, helps you sort of to visualize different scenarios that you might actually be in. So thank you. We did have a question or two come in during the presentation, but for the viewers on still, free to continue to submit those either via the chat bubble at Emily, that's me, or on Twitter with the hashtag TracklightWebinar. So Nicole, here's our first question. Okay. One came in, says, how do I know with certainty that my IP has achieved trade secret status?
You don't. Really, there's no way to get that short of litigation. And so my advice is if you consider something confidential and valuable to your business, treat it as if it's a trade secret. Hopefully by treating it as a trade secret, it's not going to walk out your door. You're going to take the security measures you can to protect it. And then if you do, you've taken those measures to hopefully argue before a court successfully that the item is a trade secret. If you have a particular item that you want some further analysis on, contact a lawyer. They can certainly give you advice in your forum, whatever your jurisdiction is, as to how, depending on what the item is, they could look at other case law and see how courts have treated similar items to see if it constitutes a trade secret in that state. There isn't going to be absolute certainty, however, absent some litigation over the matter.
Great, thank you. Yeah, and like you said, I didn't realize that trade secrets are defined differently within each state. So depending on who asked that question, what state they're in, probably, yep, like you said, be best to contact a lawyer.
Yep.
All right, let's see. Will the IP that I protect as a trade secret have more value for purposes of valuation if protected under a different form of IP protection, for example, a patent?
No, I don't think that's going to have. The one instance where I could see that possibly having effect is, let's say, the patent has 20 years of duration, and so if you have litigation over it, typically your let's say you get as damages a licensing fee that's not going to extend beyond the 20 years. With a trade secret, it's conceivable possible that you could argue that your trade secret's going to have value beyond 20 years, and so you should get damages beyond that time frame. I think that's sort of a rare situation where that's going to be the case, where you're going to get into an issue about damages that far into the future.
All right, thanks. And then next we have another question that came in during the webinar. Is there a specific limit on how many people I can expose my trade secret to before it loses its status as a trade secret?
No, there's no specific limit. And I should note that with respect to the reasonable security measures, courts can be somewhat forgiving, I think, to smaller businesses. If you're taking the basic measures of marking it confidential, password protecting it, telling your employees that you consider it a confidential trade secret, the fact that you haven't done everything within your resources to protect it, I think courts can be forgiving, particularly the smaller your organization is. The courts would say, you've got less resources to do things, you're not going to be able to install security cameras and security guards, et cetera. And so the courts can be a little more forgiving. I've actually had a case before where the defendant accidentally attached a copy of their trade secret to their, they were the plaintiff. They attached a copy of their alleged trade secret to their complaint and filed it publicly. Now, I tried to make some hay of that with the court, but I think because the plaintiff wasn't that sophisticated, the court was fairly forgiving on that point.
Wow, what a situation.
Yeah.
Oh, gosh. So just a couple more questions. I'm an entrepreneur starting a software company. What are the trade secrets I need to be aware? What are the trade secrets I need to be aware about in my business?
Sure. So if you're developing software, certainly, and state laws will vary on this, but I think your coding can likely be a trade secret, and so I would protect that as if it's a trade secret, as well as any sort of, I'm guessing if you're developing technology, you probably have a strong business plan in place, a strong plan as to how you're going to market that product and who your customers are going to be. And so I would also consider any plans you have related to the product. I would consider those a trade secret and protect them as such.
All right, thanks, Nicole. And let's see, what's our time? 11:52. All right, we got time for a couple more. By identifying my trade secrets, will it have an effect on my bottom line? Are trade secrets considered assets?
Oh gosh, I've never been asked that before, but I don't believe so. I've never had a situation. We have a large tax group here at Quarles and Brady, and we've never had a situation where I've had a client come back and say, "Your tax attorneys advised me that I needed to identify this as an asset." So I don't think that would be impacted, but you may want to consult your state attorney on that one.
All right. And let's see if we've got a couple here. Can you register trade secrets? We sort of went over that, but
No. You don't want to do anything that might publicly disclose trade secrets. So no, I wouldn't register.
All right, great. Well, I think that's everything. So thank you, and thank you everybody for attending. We had some great questions. Next month's webinar will be presented by Jennifer Hill. She's a international startup lawyer turned entrepreneur. So she'll be sharing her tips for making the transition to entrepreneurship, actions you can do to prepare yourself, and we'll also be offering guidance on pursuing your entrepreneurial interests. So again, if you haven't already, be sure to sign up for TrackLight's blog. We'll be recapping all of your fantastic questions today with answers in this blog, as well as providing a link for both the slides from today's webinar and the recorded webinar as well. And then lastly, another big thank you for all of you for attending, and to Nicole as well. It was a very informative presentation, and hopefully it helps you realize how important your trade secrets and IP are to the success of your company. So if you have to get started identifying your intellectual property, feel free to contact us at info@tracklight.com or check out our new interactive live chat feature on our website. So thanks everyone and have a great day. Thanks so much, Nicole.
Thank you, Emily.